to the quarantine room, except for Mr. Innocent Bepura, who is the first candidate to be interviewed this morning. I appeal to all those in attendance to exercise silence throughout the proceedings to enable the commissioners to do their work of carrying out the interviews without interference. I thank you. Thanks. Yes. Okay. Yes, welcome back, Mr. Bepura. I have 3 questions to put to you. The first question is as follows. How does the compulsory arbitration mechanism in Section 93, subsection 5, subparagraph A and C of the Labor Act correspond to the constitutional guarantee of the right to access the courts under Section 69 of the Constitution of Zimbabwe 2013, if it does?
Sorry, Honorable CJ, you may come back again.
How does the compulsory arbitration mechanism in Section 93, subsection 5, subparagraph A and C of the Labor Act correspond to the constitutional guarantee of the right to access the courts under Section 69 of the Constitution, if it does?
Thank you very much, Honorable CJ. Firstly, compulsory arbitration entails that in a scenario where the labor officer finds that after having tried to conciliate a dispute of interest and the conciliation fails, and where there is the dispute involves essential services, then he has to refer it to compulsory arbitration. Then, if it is a dispute of right, he also have to refer it to compulsory arbitration. And where after the compulsory arbitration, the labor officer fails to settle the said dispute, the aggrieved party can then approach the labor court. This is where the issue of access to court as enshrined in section 69 entails. So this therefore means that in any case where a person is not satisfied by the decision of the labor officer in relation to compulsory arbitration, he have got every avenue that is provided for by section 95 subsection section 93 subsection 5 to refer the said dispute to the labor court for adjudication. Thank you.
Yes. The second question is as follows. How would you distinguish between a question of law and a question of fact in determining the grounds for an intended appeal from the labor court? And what implications would this distinction have on the intended appeal's prospects of success?
I would require you to come back again.
Yes. How would you distinguish between a question of fact, a question of law, and a question of fact in determining the grounds for an intended appeal from the labor court? And what implications would this distinction have on the intended appeal's prospects of success?
A distinction between a question of law and a question of fact is that a question of law specifically deals with the interpretation of the law. That is, whether or not the law has been correctly and accurately interpreted. And then a question of fact deals with whether or not the facts have been correctly interpreted in line with the law that is applicable in respect of that case at hand. Then there is the second part of the question.
What implications what implications would this distinction have on the intended appeals prospects of success?
Thank you, Honorable CJ. The distinction that I have given on the difference between a question of law and a question of fact is that when we are talking of prospects of success, we are saying whether or not the appeal have got hopeful grounds of succeeding. So this distinction now will entail that when the court is dealing with the appeal in light of factual grounds, it is only looking at whether or not the court erred in analyzing the facts only. And when we are talking about an appeal in relation to question of law, we are saying whether or not the court properly applied the law in the circumstances. So this distinction will help to show that this distinction will entail that the Court of Appeal is mainly supposed to look on whether or not there is a proper misconstrue of the law or improper application of the facts to the law.
Yes, the third and last question is as follows. Does the right of an employer to commence disciplinary proceedings against an employee prescribe? Justify your answer.
The right of an employer to commence disciplinary proceedings of an employee prescribes in terms of Section 94 of the Labour Act. This act entails that an unfair labor practice, because sorry, I want to revisit my answer, because Section 94 only entails a prescription of an unfair labor practice to an employee. So I think that an employer can discipline an employee on any other debt which does not amount to prescription.
Yes, thank you. I will now hand you over to the other commissioners to ask questions if they have. Yes, TCJ.
Thank you, Honorable CJ. Good morning, Mr. Bepura.
Morning, Deputy Chief Justice.
I have one question for you, and it goes as follows. Having regard to the provision of Section 176 of the Constitution, how do the powers of the Labour Court differ from those of the High Court?
Section
176.
Section 176 talks about inherent jurisdiction. So the powers of the Labour Court differs with the powers of the High Court in that the Labour Court does not have inherent jurisdiction. Its jurisdiction is primarily limited to those cases that are provided for by Section 89, subsection 1, which are cases involving applications that have been brought in terms of the Labour Act, appeals that has been brought in terms of the labor court, cases involving matters that are referred by the minister, and reviews like the High Court. So it does not have inherent jurisdiction. Its jurisdiction is only limited to those which are prescribed by Section 89, subsection 1. And Section 89, subsection 6 gives the labor court exclusive jurisdiction to deal with all labor matters as prescribed in subsection 1. This issue has, however, been contentious because there are some academics and some courts which have gave some divergent views on whether or not the powers of the High Court and the powers of the Labor Court in relation to labor issues, whether or not they share concurrent jurisdiction, but their powers differ because the High Court have got inherent jurisdiction and the Labor Court does not have inherent jurisdiction. This issue of their difference was prescribed or clearly outlined in the case of Nyahora, where the court clearly stated that the powers of the High Court is primarily limited to all other labor matters that are excluded, that are not included in Section 89, subsection 1. There has, Deputy Chief Justice, some issues on this subject.
We don't want a lecture from you.
Yes, thank you.
Answer the question.
Yes, I think I have.
I think you have answered
Thank
the
you,
question.
Deputy CJ.
Yes, thank you.
Thank you.
Thank you, Honorable Chief Justice. If I may pose a question. Mr. Bepura, good morning to you.
Morning, Commissioner.
Yes, I am also going to pose one or more questions depending on your responses. Now, a look at your personal profile shows that you've got a propensity to commit road traffic accidents. In fact, maybe just to remind you, if you still recall, your history includes 3 major incidents starting from 2014, 2016, and 2022, where you were involved in various acts of misconduct involving your usage of work vehicles. Now, based on that, my question is, how then do you believe the Commission, how can you make the Commission believe that this conduct is not going to extend to the next court which you are aspiring to join?
Thank you very much, Commissioner. Yeah, I am glad you said accidents. These are accidents. On the first instance, it's I was coming across a truck and I think a boulder fell on the bonnet of the truck. That was unavoidable. And on the second incident, I think we had gone for a workshop. I parked at Holiday Inn Blawayo. When I came back from the room where we were having a workshop, I found that the vehicle which I had been driven had a dent near the bottom, near the rear light, rear front light. So
sorry, I need to interject, Mr. Bepura. We're not carrying out another board inquiry. What I have on paper shows the 3 incidents were committed by yourself, and the second one you committed whilst on suspension. Do you agree with me? You were on suspension when you committed the second incident. So the simple question is this not going to repeat when you go to the labor court? Just confine yourself to that. Thank you.
that we will not repeat, Commissioner. That will not repeat.
Thank you, Chief Justice. I have no further questions.
You agree that you drove this motor vehicle whilst you were in suspension, when you were not supposed to drive that car?
What happened is that the Commission had not served me with a suspension letter. They had not.
If it when you had been told not to drive the car because of the previous accident that was being investigated?
I had not been told, I had not been written I had not received any suspension letter from the Commission that I had been suspended from driving.
Thank you, Chief Justice, and good morning, Mr. Bepuna. Good morning to you.
Morning, Commissioner.
Yes. Now, I have one question for you, but it's split into two parts. And the question follows, right? What is the effect of, number one, an appeal to the Labor Court on the determination or decision being appealed against? And number two, an appeal to the Supreme Court on a Labor Court judgment or order.
Can you come back again, Commissioner?
Yes. What is the effect of, number one, an appeal to the Labor Court on the determination or decision being appealed against? Number two, what is the effect of an appeal to the Supreme Court or a Labor Court judgment or order?
Thank you very much, Commissioner. I will start with the effect of an appeal to the Labor Court. Section 92E, subsection 2, stipulates that that appeal will not suspend the decision that has been made. This was clearly outlined in the case of Mazikanda. And the other courts, there are other decisions of some courts which have, however, held otherwise, holding to the common law principle that a decision of the tribunal will be suspended upon appeal. But the reading of the section 92E subsection 2 will show that that decision will not be suspended pending appeal. However, when it now relates to the appeal to the Supreme Court, the decision of the Labor Court will be suspended pending appeal. Thank you very much.
Thank you, Chief Justice.
Yes, thank you. Thank you, Honorable Chief Justice. Good morning, Mr. Bepura.
Morning, Commissioner.
I'll probably just have one question for you, which goes, under what circumstances in an appeal to the Supreme Court can the Labor Court's judgment still be executed or implemented pending the appeal determination?
Execution pending appeal will be done when the judgment that is, there are no prospects of success there. The appeal is hopeless, but the order for execution pending appeal will have to be applied to the Supreme Court. So basically, the execution will be done when the appeal is hopeless. There are no grounds under which the Superior Court will probably interfere with the decision of the court accord.
Thank you, Honorable CJ.
Thank you, Honorable CJ. Good morning to you, Mr. Bepura.
Morning, Judge President.
I do have one question for you. What factors does the Labor Court consider in the assessment of damages in cases of unlawful dismissal?
The question that we have posed, Honorable Judge President, is clearly answered by Section 89, subsection 2, subsection C, Roman numeral 3, which states that when the court has decided to give damages, it should give or ascertain the specific damages that are there. So, as I have stated there, it is supposed to look on the damages that have been accrued from the date of alleged unfair termination or alleged dismissal by the employer to the date when the employer was reasonably expected to be employed, or to the date when the employee got new employment. This issue was clearly outlined, Honorable Judge President, in the case of I understand this Zupco was the other party, I forgot the other party. So in that case, it was stated that the court will be trying to restore the employee at the position which was, that is, status quo ante to the position which was. So that is basically how the court assesses damages.
Thank you, Honorable CJ.
CJ, thank you very much. Good afternoon, Mr. Bepura.
Good morning, Commissioner.
Thank you very much. I thought you would say good afternoon. Mr. Bepura, I just want to find out whether there are any lawful limits that can be imposed on the right of employees in Zimbabwe to form and join trade unions and or employers' organizations of their choice.
Thank you very much, Commissioner. Section 65 of the Constitution is instructive on that question. It clearly states that, except for members of the security forces, all other employees can join and form trade unions or employers' organizations. So the exception for trade unions is for members of the security forces. All other employees do have the right to form trade unions as provided for by Section 65 of the Constitution. And this right is also provided for in Section 4 of the Labor Act, the right to join, form a trade union. So the limitation only applies to members of the security forces.
Thank you very much.
Thank you, Honorable Chief Justice. Good morning, Mr. Bepura.
Morning, Commissioner.
My question is in two parts. It goes like this. What are the limitations regarding the Labour Court's authority to rescind or vary its own orders upon application by either party? That's the first part.
Can you come back a bit fast, Commissioner?
Okay, I'll take it slowly. What are the limitations regarding the Labour Court's authority to rescind or vary its own orders upon application by either party? The second part, does such an application stay the execution of the pre-existing court order?
Does
such an application stay the execution of the pre-existing court order?
Section 92C of the Labour Act is instructive on that issue, Commissioner. The circumstances in which the Labour Court can grant an application for rescission of default judgment are that, firstly, where the order has been granted in default, and secondly, where the order has been granted by mistake or by fraudulent means, and also in a bid. This can all be done on application. And also in order to correct patent errors which are common to parties. These are the circumstances according to section 92C, where the Labour Court can rescind its own judgment. And the second part is, does such an application stay execution?
Yes.
Okay. That application will have an effect of staying the execution of the judgment.
Thank you. I'm answered.
Thank you, Chief Justice. Good morning, Mr. Bepura.
Morning, Commissioner.
I have two questions for you. In your application or nomination form, you indicated that you have interacted with the Labour Court. In what way and when and in what capacity did you interact with the Labour Court?
As a magistrate, my interaction with the Labour Court relates to registration of Labour Court judgments in terms of section 93B subsection 2. You know, Commissioner, that we do register those.
I do know, and you're a regional magistrate, which is why my question specifically said when, because regional magistrates do not do that. So when did you do this and in what capacity?
When I was the resident magistrate for Mutare Civil Court, I dealt with a number of such applications. That could be in 2018, if not mistaken, 17 and 18. I did registration of such applications, many of them.
Then my second question is a follow-up to a question you were asked earlier. The question was, you had an accident while driving a JSC vehicle when you were suspended from driving JSC vehicles, and you said you had not received a letter. What do the conditions of service say on that point?
Conditions of service, you can clarify that.
Conditions of service for the use of JSC vehicles, specifically Section 7V or Section 7.5.
Thank you very much, Commissioner. It states that when we have been involved in an accident, you cannot drive the vehicle pending clearance by the Secretary, and the rules were new by then.
The rules were new,
The rules
so
were
you
there,
didn't
sorry
know?
to the rules were there, they were new. Just that they were new according to you.
Okay.
I'm wondering whether I heard you right to say the rules were there, but they were new. Oh, how?
You are right, David CJ.
Are you saying the fact that they were new? Yes, they should not be obeyed.
Okay.
That's what you are saying? No. Yes.
No.
Sorry.
What are you saying? You are saying the rules were new by then. Why did you say, what did you want to convey?
I wanted to say the police directive had just been instituted some few months back from the date of the accident.
It should be obeyed, disobeyed. Is that what you are saying?
No, that is not what I'm saying, Commissioner. Honorable CJ.
I think I have an answer, Chief Justice. Thank you.
Thank you, Chief Justice. Good morning, Mr. Bepura.
Morning, Commissioner.
Yes. I have one question for you, which is more of a follow-up on the question that was asked by Commissioner Moyo. Labour Court is a specialized court, and you have been a regional magistrate for 4 years. I do not see anything in your professional legal experience that has prepared you to be a judge of a specialized court. I've also noted that you did not perform very well in the first part of this interview process, the written examination that you did. You were not very good in both the substantive and procedural issues that were raised in that question. The marks that you got mainly were from your ability to interact and use the ICMS. So my question to you, Mr. Bepura, is that, do you think you are ready to be a judge of a specialized court?
Thank you very much, Commissioner. I will say that I am very much ready to be a judge of the specialized court. Given that I have been a judicial officer of the highest jurisdiction in the land in terms of magistracy, and I have prepared myself even academically, not in court specifically, even academically, because I have also shown some interest in advanced studies, because I also had some specialization in labor law in my studies at master's level. If you check on my, one of my masters, which you have there. So I studied at advanced level labor law. I have also read a lot of cases relating to labor, and I have acquainted myself with the law relating to labor and all the jurisdiction relating to labor. So I think I've prepared myself to be a judge of the specialized court, being the labor court.
Thank you, Chief Justice.
When we look at people who would want to be appointed to high offices of a judge like you are, integrity is a very critical factor. Now, are you still saying that you were never suspended from driving JSE motor vehicles for 6 months after the first accident you had? Are you insisting? I asked you a question and you said no, you were not suspended. Are you still saying that? Or
You mean the first accident, Commissioner?
you had the first accident. You are the best person to know what you did. You had the first accident. You were then suspended from driving a JSE motor vehicle, but you took the motor vehicle nonetheless when you were under suspension. You seem to be saying you were not suspended. Is that what you are saying?
No, Honorable CJJ. What I meant to say is that I had not received a letter of suspension, but I was suspended by operation of the law. That is what I meant there, Commissioner.
You're not saying the truth, because you signed for a suspension letter on the 1st of June 2022. You were given, we have it in record here. Did you receive the letter from the Chief Magistrate on the 18th of August 2022 on these aspects, where you were given a warning?
I received a warning, not a suspension letter. Yes. Yes, that is very correct.
If you received that warning, in that warning letter, the following is written: you were suspended from driving JSE vehicles pending the outcome of a board of inquiry into your accident. Despite this standing directive of the suspension, which you signed on the 1st of June 2022, you took and drove the Beitbridge Magistrates Court station vehicle in which you got involved in another accident. So you must have signed for that suspension.
I think there was an error there, CJ. I did not sign the letter of suspension. That can be verified.
But were you advised of being suspended?
I was not advised of being suspended. It was said that you should have taken cognizance of the instrument that was read by a commissioner there. Not that I personally received a letter of suspension. I did not. That can be verified.
When you received the letter of warning with this indication that you had signed that suspension, did you query it?
I did not query, but the letter of warning came after I did not query on that.
Sorry?
I did not query on that.
Yes, but you received the letter of warning. On the letter of warning is written 28th of August 2022, which you received. You received that letter, isn't it?
Yes, I confirm receiving the warning letter.
Yes, that letter tells you you had been suspended, but you did not comply with the suspension. You drove the car and got into another accident. That letter is saying that. You did not query that.
I did not query that, but if it is saying that I drove the vehicle and got involved in another accident, that again is not correct, because I did not.
Yeah, but there's a specific date that you did receive the letter of suspension, which you signed on the 1st of June 2022. You didn't query that.
I did not query that.
Thank you. We have come to the end of your interview. You may be discharged.
Thank you, Honorable CJ. Thank you, Commissioner.
Thank you. Is that enough? Just one. Ms. Pepe, we welcome you back to the interview room. As I indicated earlier on, I will ask you 3 questions. The first question is as follows. How does the compulsory arbitration mechanism in section 93, subsection 5, subparagraph A and C of the Labor Act correspond to the constitutional guarantee of the right to access the courts under section 69 of the Constitution, if it does?
Thank you, Chief Justice. If you may repeat it once again. If you may repeat the question once again.
You want me to repeat the question?
Yes.
You want me to repeat it?
Yes.
All right. How does the compulsory arbitration mechanism in section 93, subsection 5, subparagraph A and C of the Labor Act correspond to the constitutional guarantee of the right to access the courts under section 69 of the Constitution, if it does?
I will say it does correspond with the right to a fair hearing because it gives a litigant an opportunity to have their case heard by an impartial body and in such a way that they are able to get a resolution that expedites them in getting a remedy. And in the event that an award is in their favor, they are then able to enforce that, thereby having the right to a fair hearing achieved. That would be my response.
Yes, the second question is as follows. How would you distinguish between a question of law and a question of fact in determining the grounds for an intended appeal from the Labor Court? And what implications would this distinction have